All right, welcome everyone to our fifth panel of the Australia-China joint workshop on biodiversity law and governance. For those who have been following the conference till now, I welcome you back because I think that we have had some wonderful time, some warm discussions on common issues that face both Australia and China, the two large countries in different parts of the world. I also would like to acknowledge that I'm speaking from the tradition from the Guatemalan clan of Darul Nation. I would like to acknowledge they are the traditional owners of the custodians of the land where Macquarie University is, and I pay my respect to the elders, past, present, and future generation. So this panel, we are going to discuss the issue about BBNJ. So of course, this is an acronym for those who are not familiar with this kind of abbreviation. It is about marine biodiversity in areas beyond national jurisdiction. So if you just kind of close your eyes and have a little bit of imagination, ocean covers 70% of the world's surface. And the oceans that are beyond national jurisdiction, which means no single country can claim their exclusive jurisdiction in those areas. Those areas covers 64% of the ocean. So, which is also like 43% of the world's surface. And so 43% of the world's surface is governed by a convention called United Nations Convention on the Law of the Sea. And what is going on now, which is very exciting process that is going on now, is that all the countries now are gathering at the United Nations headquarters to discuss an implementing agreement of the UNCLOS regarding how the international community could better govern that 43% of the world's surface. So think about that. That's just such a huge area. And China has a very long coastline. I believe, if I'm not mistaken, 16,000 kilometers. And then Australia, of course, is a country guarded by sea. So even though, I mean, Australia and China are not necessarily the only countries that are involved in the BBNJ negotiation, I think what is going on regarding this, how could we develop a treaty towards the sustainable future of the high seas should concern both countries. I think it is in this context that I'm very excited and delighted to welcome today's panel. And we have a fabulous panel, a list of speakers that will discuss these issues from different angles. So now let me introduce our first speaker, Associate Professor Cao Ling. Cao Ling is currently an Associate Professor from the School of Oceanography at Shanghai Jiao Tong University. She completed her PhD in Natural Resources and Management and Environment at the University of Michigan, and also worked at Stanford University for 5 years before heading back to China. So, and also this is also the first time I kind of discovered from your bio that Professor Cao Ling grew up on a family fish farm in China and trained as an agronomist and environmental scientist. So, I mean, this is really something I think rooted deeply in the family tradition. That's now I understand you much better why you are so keen in those kind of research that you are doing about fish farms and also the sustainable food and sustainable marine food and so on. So her research has focused on interdisciplinary research as an interface between marine conservation and sustainable fisheries and aquaculture management. Published extensively in high-profile journals. I've read many of them: Nature, Science, PNAS, and also recently she has been named, actually selected as one of the Pew Marine Fellows globally. So that is a kind of the latest honor on her long kind of CV. So without further delay, now let's Professor Cao, the floor is yours for your presentation.
Thanks, Professor Liu, for the introduction. Let me share my screen first. Can you see my screen? Okay, thanks again to the organizers for the invitation. Hi, good morning, good afternoon. I'm Lin from School of Oceanography, Shanghai Jiao Tong University. My research mainly focused on sustainable fisheries and aquaculture policy and management, as well as marine protected areas, both in nearshore and high seas. Today, I'd like to share with you some of our recent work in identifying potential protected areas in areas beyond national jurisdiction. First, to give you some context, the oceans are the largest carbon sink on Earth, absorbing 1/3 of the CO2 produced by human activities, and over 90% of the heat generated by global warming, and play an important and central role in mitigating climate change. For example, the Southern Ocean is one of the key regions for climate mitigation, which accounts for 25 to 50% of the ocean-wide carbon flux. If the ocean global temperature increases are expected to reach twice of the currently observed values. More importantly, the oceans are rich in biodiversity. For example, taking the Southern Ocean as an example again, it is one of the key areas of global biological resources, such as Arctic krill, Antarctic krill, and toothfish, one of the world's most economically important fish species. According to the UNCLOS, marine areas beyond national jurisdiction include high seas and international seabed areas, covering about 64% of the global ocean surface, as Professor Liu just mentioned, and 95% of the ocean waters. Here on this map, the dark blue represent ABNJ. It is rich in biological energy and mineral resources and contains numerous rare and fragile ecosystem and species such as algae, sponges, corals, and some species with commercial and medical values. It is a key area for global ocean governance and as a strategic point for resources exploitation, global environmental and climate functions, and national security. ABNJ also covers the largest ecosystem in the world, and much of it is still poorly understood. The areas contain diverse habitats such as seamounts, trenches, hydrothermal vent, and cold seep. And these diverse habitats support a rich diversity of organisms, and still many unknown species that are continued to be discovered today. In addition, ABNJ is also one of the main areas for climate mitigation. In recent years, the conservation and sustainability of marine biodiversity in ABNJ has become one of the most important issues in international ocean law and ocean affairs and cooperation among countries. However, while ABNJ are usually far away from our land and more difficult to reach, they are already subject to numerous disturbances from human activities. High seas are currently affected by climate change, pelagic fishing, shipping, while the seabed areas are affected to various degrees by bottom trawling, seabed litter, and seabed mining. Current ocean acidification, warming, and habitat degradation have led to a decline in marine biodiversity in the ABNJ, and therefore urgent conservation is needed. However, to date, marine protected areas, MPS, and other effective conservation measures, OECMs, cover only 8% of the global ocean and are concentrated inside the EEZ. There are basically very limited protected areas in ABNJ except for the Southern Ocean and Northeast Atlantic. The establishment of protected areas in ABNJ is very challenging and involves the interest of different parties. In the case of the Ross Sea, for example, it took decades of negotiations from proposal to final establishment of an MTA. It is now the largest MPA in the world and a model for the establishment of protected areas in the high seas. And BBNJ conservation and sustainable use are ocean issues that are complexly coupled between human and natural systems, relating to interactions between multiple natural systems and social systems, including issues such as benefits, equity, intellectual property rights. Although a few MPAs have been established in ABNJ, research on the conservation and sustainable use of BBNJ is still inadequate, mainly in the four areas. First, insufficient scientific understanding of the BBNJ. And second, shortcomings in zoning management systems and assessment. Third, large differences in legal ownership of resources. And fourth, the difficulty in design of the benefit sharing system. So since I'm a lateral scientist, so my team and we focus on the first challenge to improve the identification and zoning management of ecologically important areas in ABNJ and hope to provide scientific evidence for decision making. We adopted a three-step approach. First, we built our own framework to identify potential areas for protection. Then we identify important areas and prioritize these areas based on scenario modeling. Finally, we compare with existing MPAs to identify gaps for protection and future MPA expansion. Currently, many intergovernmental organizations, IGOs, and environmental NGOs have put forward criteria for areas that need conservation. For example, the CBD, FAO, and IMO, they all have established a set of criteria for identify important areas for conservation. However, different criteria that these organizations have been established are for different purpose and playing different roles. For example, CBD aims to identify IPSAs suitable for designation as MPAs, while FAO and IMO apply their criteria to protect areas where human activities may reduce biodiversity. So these areas are matters of debate in many organizations. So we compared different criteria and found the first three criteria are most commonly used. We especially analyzed IPSAs described by CBD. So IPSAs mainly considered to protect unique habitats and indicator species. As for unique habitats in the whole marine ecosystem, as I mentioned before, there are very special marine habitats such as seamounts, trenches, cold seep. So these habitats are high in biodiversity and are usually important habitats for many endangered animals. So the presence of these habitats often means these areas have very high conservation value. As for indicator species of biodiversity, hotspot areas in the deep sea, cold water corals and sponges are usually commonly used. So of the 204 IPSAs described earlier by CBD, only 31 are only located within the ABNJ, and no new high sea IPSAs have been proposed in the last 5 years. And there are still very significant vacancies in the Pacific Northwest. The existing IPSAs in the ABNJ are huge and usually not conducive to selection and delineation of MPAs. Based on the screening the area of previous other organizations, we used the spatial planning software zonation to identify potential conservation areas based on the 30% of the global ocean conservation target, the best data sets such as IUCN, Aquamap, and other published in literature. We found that potential protected areas of global ocean are mainly located in the near shore, island arcs, and islands, around islands, ocean ridges, and coral triangle, and the Caribbean Sea. Of these, 47% are distributed within the EEZ, and the other 53% are distributed within ABNJ. The result is consistent with the literature, but we found more areas located in the submarine plain areas in this study. So we identified a total of 32 potential protected areas in this study, mainly in the North Pacific, North Atlantic, Southern Ocean, and ocean ridges. 8 of them identified as IPSAS by CBD, but 15 are not within the existing IPSAS discussed by CBD and need further research attention in the future. Among the records of the global MPA distribution we obtained from the UN WCMC. So the protected areas in ABNJ are concentrated in Southern Ocean and North Atlantic Ocean, covering only less than 2% of the total area of our the potential protected areas we identified in our study. As can be seen from the map here, most of the potential protected areas are still gaps, should be considered as urban gaps. So this is just some preliminary results we found. Our next step is to use remote sensing and ocean current models to take collectivity into consideration to further improve the accuracy of our identification. To conclude here, based on our preliminary findings, we found that there are still large gaps in the conservation of ABNJ, and Eulyclius species special importance to life history of species and importance to threatened species. Those 3 criteria are most commonly used. And currently, the IPSAS do not fully cover potential conservation areas. We identified 32 potential conservation areas, and only the Southern Ocean and Northeast Atlantic are partially covered by MPS. That's what we found. That's what I want to share today. Thank you very much.
Oh, thank you so much, Ling, for your insightful and also very kind of timely presentation. And also, I mean, the timing you control very well. And so I'm now inviting burning questions from the audience. Oh, I see there is one. Wow, good. And also, so if you have any questions, you can either put your question in the Q&A or put in the chat box. So there is this one question from Lyndon De Venture. How do the potential conservation areas overlap with International Seabed Authority exploratory permit areas? Ling, are you happy to answer now, or you can also type you can also have some thoughts and then type your answer later.
Okay, I will type in later. So
okay.
I thought we would do the Q&A at the panel. So discussion.
Yes.
So we would do after each presentation, or
I'm just inviting some burning questions. We will have a Q&A in the end, but at this stage, just some burning questions. And I do have one for you, taking the liberty as the chair. So yeah, I know you are a scientist. That's why your focus is question 1, to identify those potential protection areas. I went to BBNJ IGC4 in New York in March. I followed the discussions on area-based management tools, especially including the MPAs. Kind of disappointingly, I think even the EPSAs are kind of sliding. Let me try to find the right word. I'm not completely kind of ignored, but is kind of sliding away from the mainstream discussions. So, I mean, EPSAs, I understand, are identified by, or even though it's a CBD process, it's pretty much mainly identified by marine scientists. So my question to you is, what is your experience with the science policy interface to communicate your research findings to the policymakers, like Professor Shi here in the BBNJ negotiation in China?
Yeah, that's a very difficult question. That's a trick question to answer. Yeah, so as a scientist, we want our findings, major findings to be used by the policy makers. But that's usually the most difficult part of our science to policy activities. I mean, I would say usually what we do is we right now we strive, we do our best to write policy memos and submit it to the central government and whoever is in charge of these negotiations. And but it really we don't know what happened to the other. We have to wait until people tell you, okay, this is reviewed by some senior officials, and then they will take some actions. But you never know what actions they are going to take. So actually, it's confidential. I don't know why, but I guess there's some reason to that. But I agree. This is the most difficult part. I would like to hear more experience or success stories from other scientists to share how to really more effectively to translate our science to policy. Yeah.
Yeah, thank you very much. I think Alistair later may share some of his insights from Tasmania. So, okay, let's move on to our next speaker. So our next speaker is Mr. Beringen. Ethan is currently in Finland, I believe. Are you in Finland at the moment? Yes, but he's a PhD student. He's a PhD student and also under my supervision, and also a member of the Center for Environmental Law here at Macquarie. He joined Macquarie last year as a master research student, completed his undergraduate study at the University of Adelaide. Who is a top student in my Law of the Sea class. His research focused on international law of the sea and international environmental law. And in particular, his master thesis and also the ongoing PhD thesis paid attention to Australia and BBNJ. So at this stage of his career as a first-year PhD student, he has already published first authored papers on both marine policy and ocean development and international law. And also his master research thesis was ranked the highest distinction last year. So I'm sure Ethan has a very splendid future ahead. And also I'm very pleased to introduce him today to this panel because his expertise is very much focusing on Australia's role in the BBNJ negotiation. So Ethan, up to you.
Thank you. Yeah, so I have had a little bit of an issue connecting, but I think we're all right now. So thanks for having me. As Nia said, I'm a PhD student at Macquarie University, and my research has been focused on Australia and what role they can have in the BBNJ negotiations. And particularly, I've been interested in looking at it from an international relations point of view. Middle power theory has been the theoretical focus, which I will get into in a bit in this presentation. So to start off with just the structure of what I'm going to talk about, first I'll give a kind of very brief overview of where the BBNJ is at. I think we're all probably quite familiar, but just to set the scene, then I'll talk a bit about Australia and middle power theory and how I see that defining Australia's role or having giving us some insight into Australia's role at the BBNJ. And then the final stage will be trying to project forward a little bit and think about what Australia's role might be as the negotiations trend towards an ending. They may not be quite there yet though. Yeah, so BBNJ, obviously we're all aware it's this agreement or potential agreement for protecting biodiversity in these high seas areas. There's those 4 package elements which have been discussed a lot. So marine genetic resources, area-based management tools, environmental impact assessments, and capacity building and technology transfer. And we're at a stage where those initial 4 intergovernmental conferences to negotiate on these package elements have all been exhausted, the last one being in March. And the next planned one in August, and this may be the last one, but as I said, there's still a way to go on some issues. In terms of a brief overview of each package element and where they're currently sitting, marine genetic resources kind of continues to be the most controversial area. There's still some distance between negotiating states about what kind of benefits should be shared from marine genetic resources, whether this should be something that's voluntary for states or not. There's been some proposals put forward in the recent conference, but nothing with broad agreement yet. I think the other areas are doing a little bit better. Area-based management tools seem to be starting to move forward and kind of getting to a point where they can see a common practice there. Environmental impact assessment, again, was pretty constructive. I think capacity building overlaps a little with marine genetic resources, given whether, the sharing of technology or other capacity building measures should be voluntary, mandatory, and that sort of thing. But overall, trending in a positive direction. So much so that some states have committed to finishing the negotiations this year. Australia is actually one of those in their closing address, and we'll talk about that in a little bit. But where we're at is that all of these areas are progressing forwards, and to the point where some states are thinking this may be the last conference in August. So my research has been focused on Australia as a middle power and how that can be used as a lens to explain some of Australia's actions within the BBNJ, their role in the negotiations. Middle power theory is an international relations theory which deals with states that are not great powers but still have the capacity to influence international relations. Australia is considered to be the key example of a middle power, along with Canada. They were kind of the models for this area of theory, and it's been quite debated in a lot of ways, but Australia has always been considered to fit this middle power status, whatever that might be defined as. Traditionally, they've been characterized as states that pursue multilateral solutions, embrace compromise positions, and are guided by notions of good international citizenship. But in more recent scholarship, people have been moving away from the idea of good international citizenship, or the idea that middle powers are somehow inherently more selfless or more inclined to follow international law. Instead, it's being recognized that middle power theory can describe some of the behaviors that these sorts of states need to engage in order to enhance their own interests. My research on Australia as a middle power at the BBNJ has revealed a similar sort of pattern of pursuing self-interest. So Australia has been described as a facilitator at the BBNJ, which is kind of in line with this middle power compromise idea. And a couple of research projects that I've worked on have looked first at Australia with marine genetic resources and what they've done there. And I found that Australia's behavior has varied between constructive and obstructive positions. So Australia is willing to be cooperative on some things, but on issues that they don't agree with, they're not being cooperative for the sake of it, and they tend to also make their feelings known on that. And I'll show a little diagram about that in a second. And then the other project that I worked on looked at how Australia has engaged with the debate about not undermining regional bodies. So when the BBNJ negotiations commenced, there was a mandate for the states to not, well, for the final agreement not to undermine what existing bodies there were. Australia has used that to their advantage in the way that they argue under the BBNJ negotiations in order to protect their interests, particularly in regional fisheries management organizations. Returning to that MGR, marine genetic resources pattern. So this was the theoretical model that I arrived at. Basically, if we follow the first branch, you can see that I found that when Australia was in favour of a measure under marine genetic resources, it tended to be more constructive. It would work with other powers of a similar size and cooperate and put forward proposals there. However, if it was against the measure, there tended to be more obstruction, cooperation with great powers in order to lend weight to their objection. And then finally, small powers seem to not figure too much in Australia's thinking. So it was more of a directive approach there. But this just is supposed to indicate broadly that Australia's middle power status does let it do certain things like being cooperative with other states, but it doesn't mean that Australia is only going to be cooperative and constructive, even though it has largely been. And this is kind of reinforced this idea of not being, not of good international citizenship, not being a selfless position by Evans, who was actually a former foreign minister of Australia. He said, the concept of good international citizenship is not the foreign policy equivalent of Boy Scout good deeds. It reflects the reality of international interdependence, the fact that global problems such as environmental degradation require worldwide actions to solve them. So Australia is invested in a lot of aspects of the BBNJ, and I think that their strategies at the BBNJ to try and facilitate, to try and help reach middle ground positions on some of these controversial aspects are born out of a necessity to help solve these international issues that they can't do on their own. I think if we had to talk briefly about Australia's interests, their key interests seem to be regional fisheries management organisations in marine protected areas generally, and they have been quite a champion of traditional knowledge as well within the instrument, which is something that I haven't really researched too much, but they've been involved with, along with New Zealand and Pacific Island states on pushing that forwards as well. So to kind of project forward and look at what this might mean for Australia's role in the concluding stages of the BBNJ. This is the statement given by the Australian delegate at the close of negotiations for IGC4. I won't read the whole thing, but there is clear emphasis on an ambitious agreement, on constructive problem solving, collaborative work, and particularly interesting, I think, as well, is the passage where it says we fully support the proposal to hold a fifth and final 2-week conference in August 2022, and they have faith that that will be able to be done. So Australia putting their position forward that they want to finish this agreement this year, which I think is indicative of the sort of strategy that they'll be going with in the potentially last IGC. One other factor which is worth considering in my theoretical framework is that there has been a change of the Australian government in May this year. It was a long period of the previous government, and the reason this is relevant is because they tend to have different approaches to middle power, to exercising their middle power strategies than each other. So it's been kind of widely agreed that Australia is always a middle power, but the way that it tends to exercise this middle power perspective depends a lot on the policy of the government of the time. So the former Liberal coalition was actually quite keen to reject the label of middle power and was very focused on bilateral relationships, so working with the United States in particular. The Labor Party has historically been more liberal internationalist or multilateral. So there is a slight difference there in the way that Australia's middle power identity is manifested under different governments. In terms of this Labor government specifically, we don't have anything really clear in terms of a broad philosophy on foreign policy at this point. This is in contrast to the Rudd government in particular. Kevin Rudd was quite clear in promoting this creative middle power diplomacy, where Australia would be really proactive and multilateral and involved in lots of international negotiations and that sort of thing. At this point, we don't know exactly what this government's plans are, and there is some question about whether they would make much of a difference ahead of August. I'm sure the plans are probably already in place, but it's worth talking about just in the theoretical, from the theoretical point of view, because it does affect this middle power identity. But they have shown that they're keen to take some more action on climate than the previous government. And also there is this quote, this kind of one quote that I found from a Guardian article, which says that Labor has promised to set domestic targets of 30% of land and sea protection by 2030, and also that they will take a leadership role in international negotiations over the high seas. What that actually means in practice, we don't really know, but there's at least a willingness to continue being active and facilitating some sort of conclusion to the BBNJ. So that's my main points for today. To summarize, I've been looking at Australia as a middle power at the BBNJ. I think it affects the way that they conduct themselves, the role that they try to fill as a facilitator, but they're not completely selfless there. They are still interested in pursuing their own goals, and they're looking to, I think, push towards a conclusion of the negotiations this year. Thank you.
Thank you, Ethan. I think that's a very comprehensive analysis of Australia's positions in the BBNJ, and I think indeed the timing is no better now. Like with the change of the government, and we will see what's going on forward. So, is there any burning question from the audience? No. All right. So we'll save some time for the final Q&A discussions. So now it is my great pleasure to introduce our third speaker of the day of this panel, not the day of this panel, Professor Shi Yubing, Professor and Vice Dean of the South China Sea Institute at the School of Law at Xiamen University. Professor Shi, of course, is no stranger to Australia. He did his PhD at the University of Wollongong. Actually, when I first met Professor Shi, we met in Wollongong when I was traveling all the way from Scotland to visit Australia in 2014. So that was the connection that Professor Shi has with Australia for this long time. And then he went back to China after completing his PhD. He is now also the editor-in-chief of the China Oceans Law Review. His research, of course, focused on the law of the sea and especially the legal protection of the marine environment. He has published widely on topics regarding reduction of greenhouse gas emission from shipping, BBNJ, and with particular interest to this panel, Professor Shi is a member and advisor to the Chinese delegation to the BBNJ IGCs, so intergovernmental conferences held in the UN headquarters in New York from the very beginning, from IGC 1 to now. So I will be very interested in hearing Professor Shi's view on his topic. His topic today is the mutatis mutandis application of the dispute settlement procedures under UNCLOS to BBNJ agreement, challenges and prospects. All right, the floor is yours.
Thank you, Professor Liu. Can you see my screen? I just shared my PowerPoint. Professor Liu, can you see my shared PowerPoint?
Yes, all good, all good.
Okay. Thank you, Professor Liu, for your kind introduction. Also, I would like to thank the organizers for inviting me to participate in this workshop. It's a good opportunity for me to learn from others and to communicate on some of the hot issues. Today, I would like to talk about the dispute settlement procedures under BBNJ. Actually, 2 years ago, I published one article in Marine Policy, but in that article, I discussed what are the main criteria for a good dispute settlement mechanism, and then I utilize those criteria to existing proposals on dispute settlement and draw a preliminary conclusion. But today, I would like to talk about this topic from a different perspective. I will focus on mutatis mutandis. Actually, this is a Latin word, and I'm not good at language, so I did some research on this term and try to utilize this the term and to do some research on whether it is appropriate to apply mutatis mutandis, the dispute settlement mechanism, under UNCLOS to BBNJ. Okay, my presentation will start from a brief introduction, and then what are the main the negotiation of states, or the main positions of states on the dispute settlement procedures under BBNJ agreement. And then I try to identify 3 main challenges of applying mutatis mutandis, the dispute settlement procedures under UNCLOS to BBNJ agreement. Then, based on previous discussion, I draw a preliminary conclusion and predict the ways forward. So first, I think everybody should be very clear about the procedure of the current stages of BBNJ negotiation. Can you still see my PowerPoint? Seems.
Yeah, it's all good. It's all good. I don't see there is any problem.
Okay. Okay. Actually, the BBNJ negotiation started in 2004. Now, almost nearly 18 years. But the dispute settlement issue, this issue has not been discussed and negotiated a lot because it's impossible for delegates to negotiate about dispute settlement before the substantive issues be addressed. That's why only in 2017, the dispute settlement procedure issue was on the agenda of BBNJ negotiations, and has then, from that year, it has attracted controversial views from different delegations. And I remember only last year, in the high seas informal working group, some delegates and also some professors started discussing about the term mutatis mutandis. So how to interpret and apply mutatis mutandis to BBNJ negotiation. So my research question is whether the dispute settlement procedures under under UNCLOS should be applied mutatis mutandis to BBNJ agreement. So as we know, so far there are a lot of proposals on dispute settlement procedures on BBNJ agreement. For example, the main one is to apply mutatis mutandis, the part 15 of UNCLOS to BBNJ. There are some other proposals, for example, modify the part 15 of UNCLOS to suit the needs of BBNJ agreement. For example, a lot of delegates suggest that we can modify the default mechanism of Article 287 of UNCLOS. Previously, that's the default mechanism is Annex 7 arbitration. Some states suggest that ECLOS could be there to replacing the arbitration. Okay, there are some other proposals. For example, Turkey, China, Colombia suggest that Part 15 of UNCLOS should be treated as applied voluntarily on a voluntary basis under BBNJ agreement. Okay, and there are also some other proposals. I will just skip them. Now, as we know, last month on May 30th, a new version of BBNJ agreement, the further revised zero draft was released. And if we look at the updated Article 55, we will see now there are 2 options on the dispute settlement procedures under BBNJ agreement. The first option is that the provisions relating to the settlement of dispute set out in Part 15 of UNCLOS apply mutatis mutandis to any dispute between parties to BBNJ agreement. Okay, and the second option is that to regulate the dispute settlement procedures for BBNJ agreement specifically, and will not link this procedure to Part 15 of UNCLOS. For example, the option 2 provides that the the parties to the dispute may try negotiation, the good office of and mediation first. If this does not work, and then they can utilize revised Article 287 of UNCLOS, that is to make the default mechanism as conciliation. Okay, but this is compulsory conciliation. So this is a new option, and it appeared for the first time. Okay, so so my task is to make a choice between the two options. So I will talk about this later. So my argument is simple. I will try to delete the first option and then treat the second option as a starting point for further negotiation. But why? Because there are many challenges of applying mutatis mutandis, the dispute settlement procedures under UNCLOS to BBNJ agreement. I list three main challenges. The first challenge is that the meaning of mutatis mutandis is ambiguous. It's not very clear. In order to reach this conclusion, I try to discuss about this from three perspectives. First, the meaning of mutatis mutandis in a dictionary. I tried some dictionaries, but if I summarize the meaning of mutatis mutandis, they share something. For example, when we utilize the term mutatis mutatis, that means necessary changes must be made. So number one, there should be necessary changes be made. Number two, the first the instrument one and instrument A, instrument B, if we try to apply the dispute settlement procedure under instrument A to that in instrument B, then they should share something. That is, they should have the same or similar facts or situations. So this is the second point. Okay, this is something that we can draw from the meanings of mutatis mutandis in a dictionary. The second perspective is the utilization of mutatis mutandis in international legal instruments. For example, in UNCLOS, Article 285. So there is an expression. It provides that this section applies to any dispute which, pursuant to Part 11, Section 5, is to be settled in accordance with procedures provided in this part. If an entity other than a state party is a party to such a dispute, this section applies mutatis mutandis. Okay, so according to this article, there are some non-state entities, for example, like ISA or state-owned companies or individuals or companies. If those entities will be a party to such a dispute, then we can apply mutatis mutandis to the procedures that originally only apply to state party. Okay, so this is the utilization of mutatis mutandis in Article 285. Then if we examine UNCLOS Article Annex 8, Article 4, there's another usage. It provides Annex 7, Articles 4 to 11 apply mutatis mutandis to the special arbitration proceedings in accordance with this annex. So we found something new from the 2017 commentary edited by Alexandra. He tries to interpret the meaning of mutatis mutandis. He suggests that when we utilize this term, it means there is no intention to deviate from the practice of Annex 7 arbitration, unless this is specifically stated. Okay, I think this is important. And also, it can be a new addition to the meaning of mutatis mutandis that we can find from the dictionaries, and agree to this interpretation of mutatis mutandis. And another example is the rules of the tribunal. Of course, it refers to UNCLOS, Article 138. So it applies in the in the context of advisory opinion, it applies mutatis mutandis to articles from 130 to 137 that originally applies to the seabed display chamber. Okay. Another example is the 1995 UN Fish Stocks Agreement, Articles 30 and 32. So in this article, the Part 15 of the dispute settlement procedures under Part 15 of UNCLOS applies mutatis mutandis to the dispute between state parties to UN Fish Stocks Agreement. Okay, so regarding these provisions, there are some discussions in existing literature. One controversial debate is that it's unclear whether the whole procedure under Part 15 of UNCLOS could be applied mutatis mutandis to the dispute settlement procedure under UN Fish Stocks Agreement. Because as we know, there are 3 sections in Part 15 of UNCLOS. So it's a number of issues, including the provisional measures. So how can we, or whether we should apply all the package of procedures to the dispute settlement procedures under UN Fish Stocks Agreement. So there are some debates. So we can say based on the meaning of mutatis mutandis in dictionary and in existing international legal instruments, this is very controversial. There's no uniform interpretation, and there are debates. Okay, and of course, regarding the main purpose of utilizing mutatis mutandis is to try to allocate jurisdiction issue and procedural issue appropriately. Okay, so this is a first challenging. So the meaning and the meaning of or interpretation of mutatis mutandis is controversial, is unclear. The second challenge is that the application of mutatis mutandis in treaties and cases is very limited and also controversial. So first, we examine the mutatis mutandis application of the dispute settlement procedure on UNCLOS.
You have 3 minutes.
Okay, I will try to be quick. Okay, so regarding the application of dispute settlement procedure on the UNCLOS 2 existing treaties, there are actually 2 examples. One is just I mentioned at Article 30 of UN Fish Stocks Agreement. But as I know, there is no so far there is no case. There's no cases addressing this mutatis mutandis issue under UN Fish Stocks Agreement. And the second example is the 2001 Convention on the Protection of the Underwater Cultural Heritage. So in Article 25, paragraph 3, there is also the utilization of mutatis, but still there is no case. So there is a very limited case. A third example of that BBNJ, the third version. Okay, we just mentioned, but because now it's just dropped. Okay, so the third, and then we will try to talk about the application of mutatis mutandis in international courts and tribunals. There are 3 cases. There are 3 cases only, but according to this case, it only involves certain procedural issues, certain procedural rules, rather than substantive rules. First one, that is in ITLOS case number 21. It involves the application of the procedure utilized by seabed disputes chamber to the procedure that can be utilized to advisory opinion. The second is the PCA case number 2012 and number 4. But in this case, there is application mutatis mutandis of substantive issues. But unfortunately, this is just one argument provided by Slovenia. It's not something that provided by the award. So that makes it less meaningful for our discussion. The third case is PCA case number 2014, number 7. In this case, that's regarding the number of arbitrators, whether it is 3 or 5. This involves only procedural issues. Okay, so the second challenge. The third challenge is that the dispute settlement procedures under UNCLOS are facing criticisms. This mainly involves whether state consent principle has been incorporated in its interpretation. Because now, as we know, there is a evolutionary interpretation. So actually, make the original consent of states when they negotiate the Part 15 clause disappeared now. So from this case, some states argue that the state consent principle was not there anymore. So they would like to, when there is a proposal on the application mutatis mutandis Part 15 to other treaties, they oppose such option. Of course, there's another issue that the types of disputes are between BBNJ and BBNJ agreement and UNCLOS are different, because BBNJ mainly involves MGR, the dispute on MGR, on dispute on ERA, ABMT. So they are different in nature. Okay, now I will try to draw a conclusion. So generally speaking, mutatis mutandis refers to the application of substantive or procedural errors from one instrument to another instrument. If we try to apply this term, then it has to meet some conditions. For example, the general facts or situations between two instruments should be same or similar. And there should be necessary changes, but what is necessary? There's no consensus. And also there should be no intention to deviate from the practice of instrument A unless this is specifically stated. And this will constitute a big challenge for the application of mutatis mutandis, the dispute settlement procedure under UNCLOS to BBNJ. Of course, there are also some main challenges. So my argument is that the option on the mutatis mutandis application of Part 15 to BBNJ is not preferred. So I would suggest that delegates can treat option 2 of the new version of BBNJ agreement as a starting point of negotiation at IGC 5 in August this year. I will stop here. Thank you.
Yeah, thank you, Professor Shi, for your very extensive and in-depth arguments against the application of mutatis mutandis of the dispute settlement regime from UNCLOS to BBNJ. I mean, I understand your arguments perfectly, but my burning question to you, once again, taking the liberty as a chair, is I recall very clearly in the IGC4 when countries asked one question like, how much money could the BBNJ have for the implementation of this new treaty, or whatever you call it? And then they even kind of introduced the representative from global environmental facilities to tell the whole delegations like, oh yes, I can't remember the figure, but apparently there are limited resources in the BBNJ. So I mean, this is not surprising, because even in domestic societies, whatever countries, China, Australia, when we try to go to court, they will also send you to mediation or conciliation first, because the court will always say no, the judicial resources are limited. So my concern is, yes, if you are not in favor of the first option, what is the feasibility? I mean, I was thinking of like the limited resources. So are you suggesting that the BBNJ negotiations should try to develop a new dispute settlement regime? Would that be too kind of costly? Just some kind of immediate kind of concerns in my mind. If you have any thoughts on that.
Thank you. Should I answer now, or we answer in the Q&A section?
It's up to you. It's up to you.
Okay, I think maybe I can answer now. Actually, you put forward a very good question. In my article that published in Marine Policy 2 years ago, I listed 4 criteria for good dispute settlement, and one of them is cost effectiveness. And so you mentioned the cost, so I agree. So this is important. But the issue is that in option 2, I mean option 2 provides a new procedure, new dispute settlement procedure for BBNJ, and it's already there, right? So and also we have many examples of such dispute settlement. Although BBNJ is an implementation agreement of UNCLOS, but of course theoretically the dispute settlement procedure can be different. And so when we compare the criteria of cost effectiveness and reaching consensus, because whether we can reach a consensus means whether we can adopt an agreement. Of course, the second factor is more important. If you just adopt option 1, it's easier and it's costly. It's less costly, but that means many countries like Turkey, Colombia, China may dislike that. So of course, China is one of the main players in ABNJ. So if China doesn't join this agreement, that may make this agreement less effective. So I think compare cost and consensus. Consensus may be important. That's why I think why the Madam Rina Lee put forward a brand new option B. I think she must have already taken this into account. So because it's important to reach a consensus among all delegates. So it seems to me that the second option can most likely attract more consensus. At least from my personal view, that I like option 2. I think we can try to polish option 2. Okay, that's my short response.
Yeah, thank you. And yeah, of course, I mean, I need to look into option 2 more carefully, but also we can further discuss. We don't need to put it forward here. Is like, I mean, is it about procedure or is it about jurisdiction? Because that's something also very different. Like, I mean, you can have new procedure but still run by the same institutions, or actually the idea is more favored in setting up new bodies, dispute settlement bodies with jurisdictions that covers the BBNJ disputes. I think that's something can be further discussed. But anyway, we can stop here and we maybe have some more time. May have some more time in the Q&A kind of session. Okay, thank you again. And all right, our last speaker of the panel, Mr. Alistair Graham. Alistair is no doubt a veteran in the NGO sector of the Australia and beyond. He has been working for the NGO since 1970s, working on issues including the development and demise of the CRAMRA, the famous mining regulation in Antarctica. I think that's a big win in the 1980s from the NGOs to pretty much provide a mining ban on Antarctica. And also, he has been working on the development negotiation and early implementation of CBD from 1985 to 1995, development of new regional fisheries management organizations in the North and South Pacific Indian Ocean, especially the Southern Pacific Regional Fisheries Management Organization, where Australia is a very active member. And also for a long time, 20 years time, he has been involved in Kamala meetings. So, I mean, I think it is a great pleasure for us to have you here, Alistair, to share your insights from the NGO world on the BBNJ negotiation. And Alistair, the floor is yours.
Thank you very much, Professor. Yes, it does make me feel old seeing all these young people. But also, by coincidence, I'd like to pick up on Professor Xi's last point, which is we are on a mission to get consensus agreement on the new major multilateral environmental agreement. and Rena Lee, the president of the conference, has done a really good job, in my view, of suggesting a whole suite of potential new text, of which the dispute settlement provisions are but one. And as Professor Shi points out, option 2 is clearly designed to facilitate an agreement in short time. But it's also worth pointing out that on that particular point, one of the key things is that this is designed to be an implementing agreement under UNCLOS, which is open to separate accession by all states, regardless of whether they're parties to UNCLOS or not. And a lot of the difficulties on dispute settlement is how to bring those few, especially very touchy Latin American states along with us, to get them inside the BB&J consensus. But I agree with Professor Shi. But I just wanted to go right back to the start of my involvement in this. And I have to acknowledge in this respect, 2 other people who I know are out there listening, which is Kath Wallace from New Zealand and Lynn Goldsworthy from Australia. We've been at this for a long time. The place I'd like to start is with the World Conservation Strategy, developed in the late 70s and adopted in 1981, chivied along by the IUCN and colleagues and sister organizations. And that, the key thing for that was that conservation was seen as an overarching framework reaching over everything, where the successful implementation would ensure that uses were sustainable. In other words, sustainability didn't exist as something on its own. It merely existed as the proper implementation of a conservation strategy. And there are 2 things I'd like to, yes, I was listening yesterday and 2 things came through to me really strongly. One was the theme of migratory species and birds linking this very workshop, which I deeply appreciate. And I think the sense of cooperating to care for other creatures is a really important thing that binds people across countries, across jurisdictions, across philosophies. And the other key thing is the extent to which it's driven by the scientific community. Science, similarly, is something where people can reach out across jurisdictions and differences. And I think these are 2 really important building blocks of any successful international conservation or sustainability agreement, is the ability to think about how it's going to work for migratory species, which turn up on everybody's doorstep. They're everybody's problem. And the thing is, if you don't do your bit, someone else is going to suffer. So that the argument for cooperation is very strong. And my experience with CAMLR in particular, but also in the development of the underlying concerns that are driving the BB&J negotiations, the scientific community has been saying very strongly, look, we have problems here. The things are not looking good. We need to change. Things need to be done. The scientific community has always been good at organizing its message. It hasn't necessarily done very well at being heard. And I think the extent to which they managed to get breakthrough on climate change is really interesting. We haven't managed to get that same breakthrough on biodiversity, and we need to hold on to that failure, or that, that lack of success so far. And when the key thing that started us working on this was the publication of a book by a guy called Norman Myers called The Sinking Ark, was the public popular report of some studies that a group of North American NGOs had done in Brazil, not on the Amazon, but on the coastal forests of Brazil, basically saying, if we don't get these habitats protected, we're stuffed. There's a lot of species that are going to fall over the edge. And this not only set the tone of basically moving away from looking at protecting charismatic megafauna on the plains of Africa to a more broader look at habitat protection as the key to delivering conservation outcomes. And that was really important. But importantly, it also created an abiding problem, which is developing countries in Latin America, especially Brazil, saw the peculiar interest by northern conservation groups in the US as a threat to their sovereignty in terms of wanting to set up parks and generally intrude on their ability to do what they wanted to do. And that duality continues today as a significant consideration which has to be borne in mind when thinking about how many states approach biodiversity conservation. We then moved into the conventional biological diversity, which at the time was being worked on by a couple of us in a small back room somewhere, and suddenly it got ripped out into the public debate when the world decided they were going to have the Rio Earth Summit, and they were actually going to adopt treaties on climate change and biodiversity. This was a pretty stunning thing. And suddenly all our lovely ideas on conservation got exposed to the real world, and before long, Brazil and friends had succeeded in disengaging conservation from sustainability. And if you look at the title of the CBD, it's conservation and